or for anybody who didn't make it, hi, welcome to the recording.
Right. So again, a huge good morning. Thank you for joining us. Really great to have you here. My name is David Hudson, and I'm the director of HR Department Clapham and Islington. And my colleague and friend here,
I'm Charlotte. I am the owner and director of the HR department, Coventry.
fantastic. So thank you for joining. Really great to see familiar faces and new faces. Lovely to have you here. Welcome to the HR How To. Just a bit of a plug. Our HR How Tos are designed to get down and dirty, if you like, around particular challenges that we know our clients are having, and are really designed to help you navigate practically through some of those. So we're going to be sharing our knowledge and our experience in the area today of dealing with employees with medical conditions, and then giving you space at the end to talk to Charlotte and I with any questions you've got. And also there's an opportunity to do that post this webinar. So today we're going to look at what are the legal requirements for employers to follow when people have medical conditions. What does the employment law say about it? How then we take that and manage it practically through short and sometimes long-term absences, looking at return to work, when ultimately do we need to go off and get independent medical advice, and balancing the needs of your own business with the needs to treat people with empathy and respect. So on that note, I'm going to hand over to our resident expert, who's going to start to share some of that.
So before we dive into it, just a small disclaimer. Obviously, medical conditions cover such a broad possibility when we're looking at it, employment terms, things like neurodiversity, physical disabilities, all sorts. So this is going to be more high level, because I think we could probably do hours and hours on how to handle just neurodiversity within the workplace, how to handle, sort of more serious conditions like cancer within the workplace. But as David said, there is a portion for questions. If it's appropriate to answer those questions, we will do that at the end of the session. If they're more specifics or more, employee specific, we can always take that offline and answer that for you, kind of on a one-to-one basis, rather than you having to kind of ask those questions in a public forum. So we'll dive straight in. So hopefully you all know that you've got a legal duty of care, and that is covered by a couple of different things that we will just briefly touch on now. So the Equality Act, which has a very specific definition of disability, where it's, where somebody's day-to-day activities will be or are likely to be impacted for 12 months or longer. So includes neurodiversity and mental health. That includes things such as cancer, which are a disability from day one, and then the more, traditional, more kind of commonly known things, physical impairments, that sort of
We'll be
stuff.
back in a couple minutes.
We've also got a couple of things to think about as well, which are the basics. When we talk about a duty of care, they are the Employment Rights Act. So that's, the employee's right to have fair dismissal, for example. It's their right to have a rep. It's their right to have, various different pieces associated with their employment that can link into the Equality Act. And then the Health and Safety at Work Act, which has been around and been amended since the kind of 60s and 70s. And again, that's about having a safe workplace for everybody, no matter what. So when we're thinking about medical conditions and how we can handle those within the workplace, those kind of are the guiding principles from a legal standpoint that, like, as a bare minimum we should be doing. We always have this thing at the bottom, so reasonable adjustments. You're going to hear me, if you've done other webinars with me, that I'm not a big fan of the word reasonable, because it covers such a broad spectrum of things. What may be reasonable for one business may not be reasonable for another. I always give the example with reasonable adjustments of, if you've got an office building and it doesn't have a lift, is it reasonable to put a lift in? And if you are a big, if you are Tesco or BP or Severn Trent or whoever, yeah, you've got the money to put a lift in. If you've a small business with 5 employees and you're lucky to own your own building, putting a lift in is probably not a reasonable adjustment. So everything is on a sliding scale. Everything is very dependent on the individual and that individual circumstances. But we keep these in the back of our mind as kind of the very basic underpinning of our duty of care.
It's worth noting as well where you've put their Health and Safety at Work Act is that in itself covers the need to manage stress at work because of its impact on not just health but safety. So there is a bit of a double whammy there, I find, in line with the alongside the Equality Act. That you can suddenly find yourself getting into risk assessment territory and all sorts where it comes to workplace stress.
So there are things like a stress risk assessment that we can put in place to try and identify triggers and to help the employees. So it's not just about, thinking about, oh, they've got, a broken leg, what can we physically do to help them? There are all other considerations that, that's a great point. So just this is the warning to scare you, to make sure that you all do what you should be doing. So you all understand, I hope, that there are consequences if we're not following those three kind of guiding principles. So we're always trying to avoid the risk of an unfair dismissal claim or any sort of disability discrimination claim. And obviously an unfair dismissal claim, as we currently stand, is for anybody who's been with your business for 2 years or more. Absolutely anybody can make a disability discrimination claim, and that they don't even need to be an employee. If they feel that you have discriminated against them because of their medical condition or their disability, even from the interview point or even from the actual job advert, they can make a claim. So put in the middle the numbers, because people always like to know what's the number. So the 44,483 is the average disability award that's been given over the last few years. So a disability discrimination claim is uncapped. So unfair dismissal has various caps to it, but for disability, it's uncapped. That 4.6 million is the one that, according to Google, was the highest award ever given for disability. So if 44.6 is the top, and the average is 44,000, that is a lot of money. And that's not including the time spent defending the case. That's not including the time and heartache that can go into a tribunal case as well. So I thought I'd put those numbers just as a kind of because you're all going to sit there and go, yes, 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 I know I need to follow the law. Yes, 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 yes. But actually, the reality is, if an employee wants to make a claim, we're talking big numbers. And it kind of feeds into that last point of, it's so you have within your gift and in your ability to document stuff, to be fair, to be reasonable, to do your duty of care and look after your employee and keep your business safe at the same time. So that's the kind of the telling off part before we dive into the rest of it. So when we're thinking about medical conditions and absences, we're really looking at two different sorts. So you've got short-term absences. That's anything generally under 4 weeks, and they tend to be sporadic. So you're talking coughs, colds, food poisoning, cheeky hangovers, that kind of odds and sods everywhere. They can add up though, and they can also be an indicator of a medical condition. I worked with somebody once who every now and then would have really terrible like food poisoning, be really, really ill. And, we said, have you actually been to the doctor? Because you keep being ill all the time. That's not normal. You shouldn't be having, sickness and diarrhea all of the time. Turns out she had an intolerance to gluten. So when she cut out the bread, suddenly much, much better. So sometimes people being off is a sign that they don't want to be there. Sometimes it can be an underlying medical condition, and sometimes they haven't even thought of it. Where we need to start thinking about handling it slightly differently is where we're moving into long-term absences. So that's generally anything over 4 weeks. It's not hard and fast rule, but generally the 4 weeks, a month is probably long enough of continuous absence for it to be longer term. And that's where we do start having to think about, how long is this going to go on for? Do we have enough information that we can make informed decisions? Do we need medical advice, which we're going to cover in a minute? Do we need to start doing home visits? Like, what is the kind of long-term prognosis, to use the medical term? What does it look like? Are we looking at another 6 weeks? Are we looking at 6 months? Are we looking at they're never going to be well enough? And as that last point says, there are different approaches to all of it. There's so much nuance to medical conditions. Like I said at the beginning of my little disclaimer, no two situations are going to be the same. And you may well have somebody in that top bracket, in that sporadic absence, that is just being a pain and is just using their sick days as kind of extra holidays. But they may not be, they may actually genuinely be ill, and there may be some underlying condition. So we can't ever kind of use the same brush to kind of varnish everybody, because it's just not, nothing is ever the same. So short-term absence. Right, I'm not going to bore you with the long list of everything, but basic things we should be doing: recording their absence. So if you're not doing them, I always recommend to do return to work meetings. They don't need to be long and arduous. If you want a template for them, we are more than happy to provide one. But it's a good opportunity to check in with that person, make sure they're actually okay. Have they been to the doctor? Have they got any medication? Have they got any other appointments coming up? And actually, it's a good way, if they're not being as genuine as you think they are, it's sometimes kind of awkward to have to sit in front of your boss or in front of your manager or whoever it is and explain, oh, well, I was kind of off because I wasn't feeling great. Okay, what do you mean by not feeling great? Just saying I was sick is not enough in my books. I'm not well. What does that mean? Is it, have you got poorly tummy? Is it poorly head? Treat them as, sometimes it's like having children, like, tell me where it hurts. Which bit was the owie? And because those things are, if you're faking it, it's hard to keep that lie going. And then, you can also talk to them about the fact that, like, this is the fifth time we've done this. This is the fourth time you've been off with a bad stomach. Is there an underlying problem? Is there a medical condition? All of those things can, we can have those conversations because you've got the paper evidence to go with it. And it helps you. That bottom one is really important. Obviously we like to believe that everybody is genuine, but if they're having lots of time out of the business, they're taking time away from other people's jobs, they're taking time away from their own job, they're not fulfilling their contract. And actually, employment law allows us, where reasonable and where we're not discriminating against them because of disability, to take disciplinary action. And having that paperwork and that paper trail of, these are all the times that we've been talking about this, these are all the times you've been off in the last, I don't know, 3 months, 4 months, last year, is useful because it's evidence for you. And back to those first slides about, defending claims, that paper trail is so invaluable because it's contemporary records of what's been going on.
The other thing with short-term absence is sometimes the patterns show that there is maybe not a genuine reason. So the classic is to look at people that are always always off on a Friday or a Monday or payday.
Just after their holidays, they get a couple of extra days of holiday, that kind of, yeah. We'll move on. So long term. So we'd always start off, generally, long-term stuff started off as a short-term absence and kind of snowballed. I'd always recommend regular contact, meeting / visiting. They may not want you to go to their house. Maybe you could meet them somewhere neutral, but you need to keep, it's always good to establish it early with the short-term absences, but that regular contact. It shouldn't just be that they're sending you a fit note every few weeks and you never see from them or hear from them again. We're not communicating via fit notes. They are your employee. Again, back to that very first slide of your legal responsibility, your legal duties. You have a duty of care to be looking after them, and you're not looking after them if you've not seen them or spoken to them and they're just passing you fit notes. They could be dead and their relative could be claiming on the benefits and claiming their pay, and they're just feeding you a fit note. So that's a bit of a...
Can you talk about a fit note? What is a fit note?
So that's anything from a registered medical professional. It used to be a sick note. They called it a fit for work note. So your GP or whoever will tick, yes, you're fit for work, no, you're not. But they recently changed, a couple of years ago, changed the rules. So people, like, there's some registered nurses that can provide them, physiotherapists can provide them, certain consultants at the hospital can provide them. So it's not necessarily from your GP nowadays, especially because it's so difficult to get, for some people to get to a GP. I've just been told, Cal, have you got a question? Do you want to jump in now or wait till the end? Oh.
Yeah, it was just about return to work interviews. Generally, who should do them? Should it be the line manager of the employee, or should it be like the HR rep of the company, or is there any sort of like hard and fast rule?
I would always say first port of call would be their manager, because you want to keep yourself as a HR person kind of for the next level of stuff. Obviously, if it's something really serious, and hopefully it's not, but if it's something really serious, then obviously the manager can get the HR person involved. Especially if you've got somebody who's unfortunate to have something like cancer, you'd obviously want your HR person to know and understand. But for day-to-day stuff, coughs, colds, migraines, that sort of stuff, totally fine for the line manager to do it. Cool. Thanks, Cal. There we go. So back to long term. So again, this is your paper trail as well. So if somebody is long term and we have no end in sight, those keeping a record of everything we've been doing, reasonable adjustments, talking about them early on, do they want to come back, or does it need to be a phased return to work? That's an adjustment. Do they need to come back? Do they need to be on light duties? What does that look like? Keep a note of everything you talk about, because there is an option, again, at that bottom one is dismissal on capability grounds. So there is the option within employment law that if things are to a point where we do not believe that they, based on medical evidence and our own meetings with them, if they're not able to come back due to their health, that would be, we do have the option to dismiss them for ill health capability. So your paper trail that I keep banging on about is really, really useful to that, because again, by dismissing somebody, you open up that opportunity for them to maybe make an unfair dismissal claim, a disability discrimination claim. And so all the stuff that you've done prior to that meeting is really useful. Everything that you've done to try and help them, calls that you've had with them. I had one client once where they kept trying to call and have meetings with somebody and they just didn't want to. They're like, I'm sick, you can't talk to me. And it's like, well, actually, we can, because you're an employee and we need to know how you are. But they kept a record of every single time they tried to phone them, every time they sent them an email, every time they sent them a letter. And it was literally just a Word document and they just were putting notes into it. But when that case then went to tribunal, the judge was able to see really quickly, oh, okay, so they phoned you 27 times over the last 6 months and not once did you speak to them. And that went in our favour, because that's showing we are trying to get hold of this person and they're avoiding us. So we could only work on the medical evidence that we had. So best practice. So Cal, this is a good one. I should have got you to say this a minute ago and then I could just flick the slide over. So the whole point of the return to work is to be supportive, but also to dig a bit deeper and to understand stuff. Because if somebody's got doctor's appointments, it's best to know up front. If someone's on medication, it's good to know if if it's something that's going to make them drowsy, especially if you have an active job, it's really useful to know those things. Anything that's ongoing, key questions that you need to ask. So things like, do you need reasonable adjustments? What do those look like? It's conversation as well, but it can be, like we talked about, can be useful if somebody you think is a problem. It can make it that extra level and more uncomfortable and more work for them, more hoops for them to jump through, if they are kind of faking it. There we go. So reasonable adjustments. Again, I'm not a big fan of the word reasonable because it's so broad and it's so vague, but I've put some ideas in there. So flexible hours. Phased return to work is a reasonable adjustment. Role changes, if they're going to be not in a senior role for a temporary amount of time, that's a reasonable adjustment. Different equipment, for example, if they need something for their desk, if they need even stuff like, had somebody who had carpal tunnel who needed a slightly different mouse mat for their wrist, that's a reasonable adjustment. It needs to work for the employee. So generally these things are a collaboration. It's not just us saying, okay, you've got X condition, so you need this, 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 and this, because this, like I said at the beginning, is not one size fits all. There is, what works for person A is not going to work for person B. So it needs to be that two-way conversation. If you're not sure, or if it's potentially going to be cost prohibitive, there are different organisations you go through. The main one is Access to Work, where the employee, especially if they have a diagnosed disability, and even sometimes when they don't have a necessarily diagnosed one, can go to Access for Work. They are a kind of branch of the government, part of charity, and they can provide stuff. I've known them provide taxis to work for people who couldn't get to work otherwise. They've provided expensive equipment, office chairs, that sort of stuff. So, but that's for the employee to access. So you can't access it on their behalf. You can help them, but you can't access it for them. And last point on this one, because I'm just conscious I have waffled on again, is document everything. So again, that paper trail, what have you talked about? What have you put in place? What have you tried? Have you reviewed it? Because what might be working, if you've got somebody return to work having broken their leg, what they need day one is not going to be the same as day 6. So keep that conversation going, keep reviewing it. It needs to kind of evolve with the person. And there we go. So these are about a little bit about seeking medical advice. So we've got the 2 general routes of occupational health, which is a bit more expensive but can be more specific, or a GP report. So GP report does normally have a small cost attached to it, but in my experience, I don't know if you found the same, GPs tend to be a little bit on the fence about stuff because they don't want to say one way or the other. So they can be useful if an occupational health assessment is very cost prohibitive, and they are useful. I have made ill health capability dismissals on the back of a GP report, but occupational health, if we're doing a top trumps, occupational health is kind of up there with the kind of king of medical reports, because they can ask specific questions and they can give you answers. So if you're unclear about what reasonable adjustments somebody needs, occupational health have access to all that information far more than myself or David ever will, because we're good but we're not doctors. So they can provide answers, they can provide ideas of is there a treatment, do they need counselling, is what else is there available. And we use those not necessarily to fire people and to dismiss them, although they can be used for that. The idea is that it's giving you a wealth of information about this person, about the medical condition, about reasonable adjustments, so you can make as informed a decision as it's possible to have. And if that decision is that actually they're never going to be well enough to do their job, and you can't make enough reasonable adjustments, the answer can be ill health capability dismissal. Put a little bit in here at the bottom just about managing that information. So these things are always done with consent. We cannot force somebody to have an occupational health assessment. And we cannot force them to give out their medical details. So what you may find is, and it generally kind of works against them rather than in their favor, but some people are very precious about that information. It is very, very personal. It's probably as personal information as you can get. So we need to have some respect for that. But we also need to be clear, if we can't get that information, we are not medically trained. So we need to make decisions, and they won't be informed decisions. They'll be decisions based on what we know and what we believe. So like I put at the bottom, they're not to dictate decisions. So if somebody refuses to share the information, it's normally because it doesn't work for what they want. So we just go with what we know. Trying to make sure I've got everything because I'm very clear. So compassion versus consistency. So if you're dealing with somebody with a medical condition, you are balancing two different sides. You have that human, emotional, empathetic side, and then you've got your business side as well. So we always need to be empathetic, because we always want to believe that people are being genuine. We always want to believe that they're telling the truth. And we always want to believe that they do want to come back to work. However, that's not always the case. So we need to be able to kind of balance those things. We need to be very clear in what we're doing. I put in there about favoritism. Just because we like them and they're a good worker doesn't necessarily mean they're not playing the system. Equally, just because somebody is a pain in the bum doesn't mean they're not genuine. So if we can keep that consistency throughout, that doesn't open us up to any kind of unfair dismissal conversations or discrimination. People can claim for disability discrimination and still be employed by you. So they can claim that you're, not respecting their rights under the Disability and the Equality Act, and still be employed by you, which is a very awkward situation to be in, where you're essentially suing your employer and you're going to work for your employer. So it's not a nice one at all. And it's always good, if you are in that higher HR role and you've got managers who are having these conversations, it's good to remind them of these things, because these can be awkward conversations to have, especially if the person is running out of sick pay, we're going to have to move into disciplinaries. All of these things can be awkward and be difficult, and it's best to have those conversations rather than avoiding having them. So we are looking at ways to keep things fair. So like David said, use those return to works to spot trigger points. It's good to have, if you use the Bradford factor, that's a really useful way of, kind of fairly giving a point system to it. You need to remember that if you're using something like Bradford factor, or even 3 strikes and we have a meeting, if somebody's got a disability, there may be the need to adjust that. It is, again, not one size fits all, because that in itself can be discriminatory. Keep documenting stuff, keep banging on about it, but it's really, really important because no matter what you do, if somebody makes a claim, that is your evidence of what you've been doing. If they've been off for a long time, we're doing those regular check-ins. I like to set that up from kind of day one. If somebody has been ill for like a week or so, it's not okay for them to just not be contacting you. You need to set that expectation that you're going to be talking to them. And then get the HR, whoever you have doing your HR, involved early, because David and I have probably seen most variations under the sun, genuine and not genuine. And although I keep saying it's not one size fits all, generally we can kind of steer things, depending on which way we want to go. And we've got so much knowledge and experience. We have a great occupational health provider who give us a lot of knowledge as well. So if you've got something that you think might become an issue, it's always worth having that conversation and just making, whoever's doing HR available, because they can then start providing support for you. So things that we've got to go through. I'm sorry, I'm really conscious of the time. So you need to remember we're balancing empathy with actually the needs of the business. Keep doing the return to works, keep documenting stuff, make sure we're being fair. If you've done one thing for one person, we need to make sure we're doing something similar for the other person. And we are always available. Like I said, we're gonna do some questions in a minute, but if you wanted to kind of take something offline, David and I are more than happy to have conversations about specifics. So I've talked enough. Has anyone got any questions?
Yeah, and just to reiterate, it's 10:29, so we're conscious there's about 60 seconds left
Sorry.
of your time. But absolutely, I agree with Charlotte that we can go off and have, particularly given the sensitivity of these things, separate conversations also. So Rachel has a question. Go ahead, Rachel.
Hello. This might be something that has to be taken off, but I'll ask it anyway. So I had somebody who resigned recently, and in their resignation, they quoted one of the reasons they were leaving was because of the impact of the role on their mental health. But they wouldn't engage in a exit interview. They weren't in when I collected the equipment, just wouldn't discuss with me. So I hadn't really thought about the well-being side of it, the stress type risk assessment thing that you were talking about. Now that we've had that information presented to us, even though I can't get specifics from that individual, would you say that should trigger the stress work assessment you mentioned earlier? Is that something that we should try and do objectively without it, being able to get the individual input?
Yeah, I would say so. I think you're on the right tracks there. You can't unknow what you've been told, and we have a duty of care to look at where those comments spring from. And you're right, equally, if the employee doesn't wish to share further detail with you, it does in reality make it quite difficult. So you will maybe want to look at what's happened around that employee. There may be factors alongside their view of stress at work that's impacted the reason to resign. But you can only ultimately deal with what you know. And so for your own peace of mind, I think you're on the right track. Go back, just assess maybe what's happened around them. And if there are things there that maybe are concerning, talk to us, and we can support you through that. But you can only work on what people tell you, and that's
Would say, if you have then recruited to replace that person, it's probably worth just keeping in the back of your mind of, do we need to have a check-in with this new person? Do we need to maybe not necessarily do the stress risk assessment if they're not, saying that they're stressed, but it's just something to have in the back of your mind of like, okay, need to keep an eye on this. Is there something genuine to it? Or is it just somebody's just spouting off words they heard on TikTok and not really giving you any information? Because it's very easy to kind of make a really kind of dramatic statement and then never back it up because you're never going to see that person again. So it's just worth keeping in mind, we've got the option to break out that risk assessment if we need to, if you think that they are struggling within that role.
Thanks, Rachel. So I'm conscious of time, so we'll move on. So just to close, thank you for coming along. Kirsty will send on the the recording to you. Please, please, please reach out if you've got more specific question. We've definitely got loads of time we can sit and chat with you outside of the webinar. A plug, we're going to be running more of these over the next 3 months. So do head to the website, please, to book up with that. And again, just to reiterate really Charlotte's point, we're here to help. So along with the recording, we will also share with you our contact details. And if you want to reach out, then please do.
That was great. Thank you, everybody. I think we'll end it there.
Great.
Thanks.
Thanks a lot. Good to see you all. Thank you.
Thanks, bye.
Bye.
Bye, everyone. Bye, Cal.